Hello class, Ian Adel here again. Today we're going to be examining Chapter 4, the General Principles of Criminal Liability, mens rea, concurrence, ignorance, and mistake for all of you Law 305 students out there. So let's get started. So it's important to distinguish between the most serious crimes that require criminal intent and criminal act. Culpability of blameworthiness is the idea that it is fair and just to punish only people who we can blame. We do not want to punish people who are not culpable. Whether we are retributionists, whether we are preventionists, whether we believe in deterrence, incapacitation, it doesn't matter. People have to be culpable or blameworthy in order to be punished. In addition to mental states, we add two more elements to criminal liability, the idea of concurrence and the idea of causation. Concurrence refers to two connections. In crimes of conduct, criminal intent has to trigger the criminal act. So that's the key. So in crimes of conduct, criminal intent has to trigger the criminal act, and in result crimes, not conduct crime, result crimes, criminal conduct has to cause the bad result. So in conduct crimes, the mental state has to trigger the act, and in result crimes, the conduct has to cause the bad result. So conduct causing bad result versus mental state causing actus reus, or the voluntary act. So be aware of those two differences between the conduct crimes and the bad result crimes. That is testable. Cause and fact, but for causation, consists of the objective determination that the defendant's act triggered a chain of events that ended as the harmful result. So, but for car A smashing into car B, which then smashed into car C, A was the but-for cause of the accident to B, and then B was the but-for cause of the accident to C. But now we need proximate cause to determine what happened to the extent of the chain of events that caused a certain situation to take place. Legal cause consists of subjective judgment that it is fair and just to blame the defendant for the bad result that takes place. But they need to be the legal or proximate cause. Legal cause always triumphs but for cause. Legal cause is the most culpable or blameworthy compared to factual cause. That is testable. That is something you need to know. That is something you need to drill into your mind. So if car B smashes into car A, which hits a pedestrian, car B is liable to the damages to car A and the pedestrian if they were texting on their phone or they were recklessly driving, because they are the legal cause. They're the factual cause to hitting A, and A is the factual cause to hitting the pedestrian, but the legal cause of the whole situation was that car B smashing into car A, which then hit the pedestrian in the crosswalk. So be aware of that. Mens rea. Mens rea is Latin for the term guilty mind. Here in law, we love to use Latin terms, well, just because it's law. The mental element of a crime, and this goes back to Plato's latest work, laid out a sort of ancient model penal code that existed back in the day, which talked about the issue going back to polity, which went back to the issue of the mens, or mens rea refers to criminal mind, guilty mind, but mens referred to the mental state that was being developed in the 5th century. So be aware of that. Premeditated murder is more severely punished than a voluntary manslaughter, excluding unintended killing. So obviously, we want to punish people who purposely and knowingly commit a crime to a greater extent than people who just recklessly or negligently commit a crime. And we're going to get into that in this video as well. There were two additional pieces of evidence that there was a mens rea requirement. Even though there was no general requirement of criminal liability, most serious crimes could not be committed without intent. So a bad result crime, you have to have intent. Conduct crimes, you have to have intent. Excuse me. Defendant's punishment depended heavily on intent. So based on your intent, to the extent of the model penal code, whether you're put into the position of purposely, knowingly, recklessly, negligently, that determines not only if you're guilty or not, but the extent to what punishment you should receive within the prescribed punishing guidelines. So if you're supposed to be sentenced 25 to life for a murder case and you acted purposely, which I mean you should if you're being charged with first degree murder and are found guilty. But second degree murder, let's say knowingly, you know what I'm saying? If the prosecution can prove purposely, but they can't prove all the elements for first degree, then that could justify giving you a greater sentence. You see what I'm saying? So that's very important to know that. Now, mens rea principle is this criminal mantra. Just be aware that in U.S. versus Cordoba Hincapi, this stated that Western civilized nations have long looked to the wrongdoer's mind to determine both the propriety and the grading of punishment. So again, it goes back to the mens rea component, the intent component, and then the agreement and fostering of concurrence to determine who should be punished to what greater extent. Complexity of mens rea. So mens rea is a very complex topic. And it's a topic that will be focused in your law school career for a very large period of time. So mens rea is difficult to discover and then very difficult to prove in the court because it's very hard to get into that person's mind and truly understand why is it that this person thinks the way they do? Why is it that this person formed the intent? How could have they formed the intent if they didn't commit the act? So just be aware of that. Courts and legislatures have used so many vague and incomplete definitions of the mental element. So courts and legislatures do not agree on what should be constituted as mens rea. They don't agree to what extent that should apply in regards to sentencing. But the legislatures have a lot more say in it because criminal law is really crafted based on aspects of the codification movement. Mens rea consists of several mental attitudes that range across a broad spectrum, stretching all the way from purposely committing a crime, meaning that you're you're totally aware it is criminal, to really just creating mere risks of criminal conduct or causing criminal harms. A different mental attitude might apply to each element of a crime, either to actus reus, to causation, to harm, to attendant circumstances. Now, a motive is what causes a person to act. So let's use the fighting example that I used in video number 3. If you fight an individual because that individual cheated on your girlfriend, or let's say that individual threatened to beat up a younger brother of yours, and you had this anger in your head and said, I'm going to go and I'm going to take care of this person, that alone's not criminal. When you act upon that, the state's now proving that you had the intent to act upon that thought. They don't need to prove that you necessarily did it because of you're angry at that person because they were cheating on your girlfriend or they were trying to harm your family member. But it is important to note that if the state can prove your motive behind something, like in a murder case or in an assault case, it makes the job of proving intent a lot easier. But motive is not required in as a criminal element in general. In murder cases, first degree premeditated murder, oh yes, it is an element. But in every other case, maybe, maybe not. It really doesn't matter. It's the intent element that matters. It's the actus reus element that matters, not motive. But motive is important for, obviously, first degree murder like it should be. Be aware of that as well. Motive, again, is irrelevant to criminal liability. Good motive is no defense to criminal conduct, and a bad motive cannot make legal conduct criminal. Sometimes motive is relevant, and sometimes it is not. Greed, hatred, jealousy are always relevant to proving the intent to kill. So like I said, when it comes to murder, when it comes to proving the intent to kill, motive is something that's looked to. But other than that, it really isn't. Like if you're in possession of drugs, unless it's for distribution purposes, they really generally don't care what your motive is. They just want to prove your intent behind that. Being in possession of the drug, the act is, whether it's actual, constructive, mere, or knowing, and then wanting to establish what's the intent for those drugs that you have in your possession or the illegal weapons. Motive is also important in some defenses and is sometimes an element of crimes. But again, very rarely. Sometimes, I would argue, very infrequent, a lot of times when it comes to proving motive. But just know the difference that motive is the why, intent is the what, and the voluntary act is the how. It's what I would say. Because how'd you do it? You stabbed the person. Okay, you stabbed the person. You did it. All right, so that's more of the how. More of the how, the when, more of the what time did it happen kind of thing for voluntary acts. All right. So proving state of mind. Confession is the only direct evidence of mental attitudes, but defendants rarely confess their true intentions. So the extent of that is that proof of their state of mind usually depends on indirect circumstantial evidence, which means that the concurrence between the mens rea and the actus reus is pretty much the only feasible way, other than direct evidence of mental attitude, to actually establishing guilt. Acts and attendant circumstances are the overwhelming kind of circumstantial evidence. By observing what I directly do, you can infer I am up to no good. So acts and attendant circumstances are the elements that ensure more of the act behind what you are doing. They are establishing the voluntary act. Because if there's no voluntary act, like I said again, there is no actus reus, and if there's no actus reus, there is no crime. All crimes, no matter what they are, from parking violation to whatever, require actus reus. But not all crimes are conduct, and not all crimes are bad result crimes. Not all crimes are misdemeanor or felonies. So the level of additional elements varies from crime to crime. But all crimes, and the starting point of all crimes, require actus reus. So be aware of that. And actus reus and attendant circumstances, because most crimes do require attendant circumstances as well. You have to act within a certain, set of circumstances. So you can't get a parking ticket for speeding. You have to be in the right circumstances for that, obviously. You see what I'm saying? So circumstances and acts do coincide a lot. So be aware of that too. You don't really need to know that until you get to law school, but just be aware of that. Circumstances and acts are very important. Criminal intent. So we have subjective fault. Subjective fault is fault that requires a bad mind in the actor, okay? We call the state mind knowingly or purposely, okay? It's frequently linked with immorality. These are also your mala and se offenses for you sociology students and experts out there. These are like depraved will, bad heart, abandoned heart, diabolic malignity. All those terms show that you had this intent. You had this evil, malicious, odious plan to carry out. Or you knew it and you just didn't care. You were consciously object to it, or you were totally aware to what those results would have caused. And that meets the specific intent requirement. So be aware. Subjective fault generally meets specific intent. Objective fault, on the other hand, pretty much meets general intent, just like strict liability offenses. But objective fault requires no purposeful or conscious bad mind in the actor. So know the difference. Subjective fault does require the bad mind in the actor. Objective fault does not require the bad mind. An objective fault, you are simply held liable because you do not live up to the norm of the average person. You deviated away from society, you acted recklessly or negligently, you should still bear the repercussions, but obviously not to a greater extent in terms of punishment if you did it. even if you are culpable or blameworthy, because you didn't act with this purposeful or conscious bad mind. All people who commit crimes that are voluntary and they have an intent should be punished, but the people who commit those crimes out of a bad act should be punished to a greater extent. That's the way our society looks at that. Specific intent. This is actual intent to perform some act along with the wish for the consequences that result from that act. Think of specific intent as general intent plus. General intent, referring to the intent to commit the act as res of the crime, and plus refers to the criminally harmful bad result / circumstance that takes place. So this really distinguishes between the conduct crime, the bad result crime. Again, see what I'm saying? Specific intent are typically in bad result crimes. Specific intent are referring to subjective faults. So you got to start being able to make these distinctions. General intent. Actual intent to perform some act, but without a wish for the consequences that result from that act. So again, you acted recklessly or you acted negligently. State versus Fleck established decides that one Minnesota assault statute is a general intent crime and a second assault statute is a specific intent crime. So be aware of that. There can be different crimes based on different levels of intent as well. Strict liability exists when a defendant is in legal jeopardy by virtue of wrongful act without any accompanying intent or mental state, and this does not include subjective or objective fault, and focuses on the idea of protecting the public health and safety under police powers doctrine. And these offenses are typically not punished to such a great of an extent as subjective fault, and to a lesser, greater extent of objective fault, and therefore the state has an interest in protecting the health and safety of the community totally based on the act, not based on intent, circumstance, etc., and therefore does warrant some punishment, whether fine, community service, limited incarceration time. But most of these strict liability offenses, you're not going to be incarcerated for anything unless you fail to serve out your sentence, your suspended sentence, or your in lieu of incarceration community service, or your post-dispositional hearing you have to go to. But that's different. That's because you're failing to honor the court. You're engaging in contempt of court. You see what I'm saying? Or you're violating an actual statute, criminal contempt, which gives courts the power of enforcing their actual agreement, their sentencing guidelines. So be aware of that too. The model penal code now. So there are levels of culpability from the most to the least blameworthy. The most blameworthy in the model penal code is purposely. You did it on purpose. You also are called to have a conscience object. You are consciously objective to commit the crime, and you are consciously objective to know the results of the crime that you have committed. The most obvious intent. Knowingly, on the other hand, is the second most blameworthy, and it's based on awareness. In conduct crimes, awareness is clear. Doesn't mean you know your acts or crimes, just that you are aware that you are doing something. You are practically certain that your conduct will cause the bad result. Knowledge is not the same as purpose or conscience objective. So be aware of that too. Knowingly, you're engaging in awareness. Purposely, you're engaging in this conscience object. Recklessly, you know that you are creating the risks of harm, but you do not necessarily intend, or at least do not expect or really care, but rather your consciousness creates a substantial and an unjustifiable risk of criminal harm. And this is both a subjective and objective test. So be aware of that too. Reckless defendants do know that they are creating a risk of harm, but do not know certain elements are certain to follow. So be aware of that. Negligently, you're just unconsciously or unreasonably creating the risks. You don't know that you're creating the risks, but a reasonable person would know it and they would avoid it at all costs. This is totally objective. Concurrence and causation now. Concurrence means that some mental fault has to trigger the criminal act in conduct crimes and the cause in result crimes. All crimes except strict liability offenses are subjected to the concurrence requirement. Okay? So, all crimes except strict liability mean that you have to have that agreement between the actus reus and the mens rea again. Causation is about holding an actor criminally accountable for the result of her conduct, her or his conduct. Only applies to criminal result crimes. Causation requires proving two kinds of cause: the factual cause or the but-for cause. Factual cause is an objective, empirical question of fact, and legal cause is simply a subjective question of fairness that appeals to the jury's sense of justice or a judge in the case of a bench trial. Please note, this is very important. Please note, which is testable too, by the way. There is no proximate cause if there is an intervening cause. For example, car A, car B, and car C are driving down the road. Car C is speeding a little bit, yes, and is getting very close. Driver's texting on the phone. But a meteoroid comes out of the sky and smashes into car A and pushes it a little faster. And if they weren't speeding to that extent, they wouldn't have hit even with the meteor falling. But the meteor still fell and perpetuated it. But the meteor still caused that issue. So that's where we start getting into the proximate cause element. Sure, yes. Car C, if it weren't for speeding, wouldn't have hit car B, and car B, if they weren't traveling behind car A, would have smashed into car A, and car A wouldn't have fell off the road, and the driver would have died, and the pedestrian wouldn't have been ran over, etc., etc. But that asteroid falling out of the sky is a perfect example of a superseding intervening cause. And if that's the case, then car A could introduce a potential defense to say, wait a minute, this is an intervening cause. There really isn't a legal cause here. I'm not the legal cause and should not be responsible. So be aware of that too. Now we're getting into some pretty basic concepts. Failure of proof, defenses, ignorance, and mistake. So the ignorance maxim is the presumption that defendants knew the law that they were breaking. Mistake of fact, a defense to criminal liability whenever the mistake prevents the formation of any fault-based mental attitude, namely, no matter what level of culpability it is. So be aware of that. And failure of proof defenses are also known as mistake defenses, which again negate the defendant of criminal liability when there is enough evidence to substantially explain that the defendant should not be prosecuted for the offense because they did not know the offense that they were committing, and it was rather a mistake, and there is not enough evidence to substantially prove the mens rea necessarily required for criminal liability. Just remember, this is really rare. You have to have diminished capacity. You have to just meet the insanity requirement, or this has to really be a mistake, meaning that you definitely had no way of knowing this law. If it was, like for example, like if the law was so vague, you didn't really know what the law was, and you committed the act, you could say it was a mistake because you interpreted the law to be differently, and the way you thought about committing the act correlated to you doing X when the law required you to do Y, but the law was written in a way that made it seem like Y was X, so you can get off that way. So there are still ways to say ignorance of the law is an exception, but generally speaking, ignorance of the law makes sure that people who are culpable can't just get off so easy, and it makes sure that people who are blameworthy enough still get punished. Now, research has convincingly demonstrated that criminal law loses its force if people believe it's ineffective or does not deserve their respect. People are more likely to obey the law if they believe the crime is morally wrong or the law generally deserves respect, and it's understandable, for example. Based on empirical research, the primary motivation behind people's intuitions about the ignorance defense is the desire to punish the blameworthy and to also ensure, I'm going to add to this, that people who are not culpable are not punished. So that wraps up our midterm review guide. Video 4 is now completed. Please send me an email if you have any questions. Send TA's email if you have any questions. Send your professor or send the professor an email. Do whatever it takes to make sure you know this content. It's not hard. It's possible to learn. Review the court cases. And I am so happy to have helped out. Thank you for this honor. I look forward to speaking with Law 305 when final exam season comes around. Thank you all.